There's some big news in the Kelsey Fitzsimmons case. Her attorneys have filed multiple new motions. This first one we're going to go over is defendant's motion for disclosure of promises, rewards, and inducements. Justin Olayan, which is her ex-fiance, non-prosecution despite overwhelming evidence of criminal activity. On July 3rd, 2025, while Miss Fitzsimmons was hospitalized at Massachusetts General Hospital fighting for her life after being shot in the chest at that time, as set forth on video surveillance, Justin Olayan forcibly broke into her residence in North Andover with 3 other accomplices. Olayan had 4 days prior obtained a fraudulent exparte family court restraining order from an affidavit full of lies about Miss Fitzsimmons, stealing full custody of their 4-month-old child and receiving an order that she stay away from him and the baby. Olayan had no residential rights whatsoever regarding Kelsey's secure, locked property. He had no business going there and no legal right to enter. In fact, Miss Fitzsimmons' father is an alarm and surveillance contractor, had just changed the locks and updated the surveillance system in the house after Olayan's surprise litigation against his daughter. As detailed in Miss Fitzsimmons' sworn affidavit, Olayan broke the front door jamb to gain entry. He entered with 3 other individuals. The surveillance system and alarms were immediately disabled and destroyed, costing thousands of dollars in damages. The modem power was forcibly pulled from its wiring. Olayan stole cash, gift cards, Kelsey's passport, her personal laptop, computer, and other valuables. Olayan stole evidence contradicting his family court affidavit, a handwritten letter authored by Mr. Olayan praising Miss Fitzsimmons as an amazing mother, removed from the refrigerator to prevent its use exposing his lies about her. Further, after stealing Miss Fitzsimmons' laptop, Mr. Olayan brought it to his parents' residence in Stowe, Massachusetts, where it connected to the Olayan family Stowe Wi-Fi network, Braceland 4. From there, he accessed her Facebook, AOL, and Gmail accounts, gaining entry to bank accounts, withdrew approximately $5,000, closed accounts, accessed her medical records, accessed her pension beneficiary documents, and canceled her travel reservations, directing funds to his own account. All of these actions were traced and readily apparent on the laptop's recorded computer history. The laptop was returned at the home at some point in Kelsey's 53-day hospitalization in what had to have been another unlawful entry, an obvious effort to conceal the computer crimes. Despite requests for investigation, sworn statements, corroboration, and video evidence, the Essex County District Attorney's Office has declined to charge Mr. Olayan with any offenses arising from the July 3, 2025 incident. No agreements, emails, texts, or other writings have been provided related to a non-prosecution. Further requests that the matter be referred to an outside prosecutor due to obvious conflicts that have been rebuffed. This extraordinary leniency in a multiple felony case involving destruction of a potential evidence in a pending criminal matter constitutes a considerable benefit, whether it characterizes prosecutorial discretion or declination. The practical effect is the same. Mr. Olayan avoided significant felony exposure. The Commonwealth must be ordered to provide or memorialize any verbal or written discussions, understandings, or agreements or positions regarding the reason or cause of non-prosecution. A jury is entitled to know whether a key witness stand in a position of gratitude, vulnerability, or expectation of continued protection. Officer Patrick McCarthy Noonan, non-prosecution, employment protections, and financial benefits. So this is the officer that shot her. Officer Patrick McCarthy Noonan shot Miss Fitzsimmons in the chest on July 30th, 2025. The events are not recorded by police body camera or residential security cameras. He claims Miss Fitzsimmons tried to shoot him without ever interviewing Miss Fitzsimmons. The prosecution believed and adopted Noonan's self-serving version of events. The Commonwealth sought to leverage shocking allegations into an assault with intent to murder charge, which was rejected and no-billed by a grand jury in favor of an entry-level superior court charge, assault by means of a dangerous weapon. The allegation that Miss Fitzsimmons assaulted Noonan hangs by a thread held only by Noonan himself. As a result, the Commonwealth is strongly obliged to make him as comfortable as possible. After shooting his colleague, he was immediately placed on critical incident leave from June 30th, 2025 through August 27, 2025. Upon returning to work, Officer Noonan resumed full-time duties and worked paid details for approximately 138 days. This was the status quo. On or about January 11th, 2026, Officer Noonan failed to report for a scheduled shift and was deemed AWOL. Officers responded to his residence for a well-being check after phone calls went unanswered. Officer Noonan eventually answered the door and stated that he had taken Flexerol and did not wake up for work. Despite this, he received only a written reprimand. He was placed back on critical incident leave effective January 17, 2026. He has continued to be permitted to work paid detail assignments while on leave. Critical leave incident is ordinarily reserved for officers unable to perform duties due to trauma. Officers placed on critical incident leave are typically removed from active duty because they are not considered fit to perform the full responsibilities of a police officer. To defense counsel's knowledge, working paid details while on such leave is highly uncommon, if not unprecedented. In fact, the North Andover Police Department collective bargaining agreement states a patrol officer on limited light duty shall not be eligible for details or overtime. The continuation of paid employment benefits following an AWOL incident raises serious questions regarding preferential treatment and whether employment protections are tied directly or indirectly to Officer Noonan's role in the prosecution. The details of these extraordinary arrangements are crucial to the defense. Paid leave, deferred discipline, employment protections, or internal agreements regarding discipline are tangible benefits. If any favorable treatment was extended in connection with his cooperation or testimony, it is impeachment evidence that must be disclosed. I'll keep you guys updated on this case. If you don't want to miss anything, give me a follow. Let me know what you're thinking about this in the comments.